Let's be clear. And you can't discharge your functions as a deputy speaker. Means I can't discharge under the 10th schedule. So that's
your
clear.
simple point is that there was no complaint under 10th schedule. Where is the question of a notice given?
Exactly. And how is this academic? The whole purpose of it was to paralyze the speaker. Purpose of it was to ensure that I do not deal with the disqualification petition when it comes. And they knew it was coming. Manoj, in politics, there is no secret.
There was already
what happens, Manoj, at one end is known to the other person. So somebody must be drafting the petition, and they must be knowing it. And let's draft a letter dated 22nd, date it 21st, and send it to them. That's it. This is practice.
Obviously, everybody knew what was going to happen.
So, Manoj,
who doesn't
say that this all is
they are times ahead of times to come.
Yeah.
It's all. Who doesn't know? Even citizens know about it. Forget about legislators.
That's right. Even citizens know. Manoj. So therefore, let's be clear. The whole initiation of the exercise.
The 10th schedule now has been internalized by the political establishment. So they knew exactly.
I said that in my opening. I said that in my.
It's been internalized. Like, they also knew exactly what's going to happen. It's like everybody is, it's like a chessboard. Everybody knows what's the next move.
Yes. Now, let's look at it from another standpoint. I'll come to the 10th schedule later.
Yes.
Another standpoint. Well, let's under the 10th schedule now, even if the majority defects, it will still be defection. There is no concept of majority, minority under the 10th schedule anymore. The only concept is of merger.
Merger, that's the only thing.
So to say that the majority, we are 40, is no defense under the 10th schedule.
But this is not a case of merger also, as
it's saying. It's not their case of merger. So to say, I've been hearing this refrain that we are 40, they are, it makes no difference. That is why para 3 was removed. These are very serious issues. You can't apply Nabam Rebia in this fashion. And therefore, Mullah, my Lord put it to me, if you have lost the plot, Mullah, we have not lost the plot. Because the 10th schedule itself allows me. There is no defense available. Which is why they don't want this to go on. Which is why, Mullah, they are saying it is academic, don't deal with it. Our speaker will decide. Now we have a new speaker. Mullah, and now we can't remove him because they have the majority now. So even if we give a notice, we can't remove him because they've toppled the government. See the serious consequences of this. And what moral principles are we talking about, Mullah? These are not conscientious objectors, Mullah, like in Soviet citizen wars, Mullah, in Russia. These are conscientious defectors. Where they lay their conscience on a platter and depends on who bids the highest. Let's not make these moral principles in this. We know what happens. So, please, I beg of you, this is not about today. This is about tomorrow. Don't board the issue, Mullahs, and say it doesn't arise. It will arise time and again. Elected governments will be toppled. And no democracy in the world allows this to happen. Why do you allow the party to use the 10th schedule? In fact, the process must be, this is my view, and when I argue the merits, the process must be that an elected government must continue till the disqualification petitions are decided. If they are disqualified, that's the end of the matter. Your Lordship is there to protect them. If they are not disqualified, the elected government will go. But do not allow the 10th schedule to topple an elected government. And do not interpret 179, 181, the moral principles that Justice Mishra talked about, to allow this to happen. It's far too serious.
So, Mr. Sibal, ultimately, equally, what your submission is, therefore, give free rein to the speaker.
No.
Free rein to the speaker.
No, Malaj.
Without imposing any restraints.
No. Please don't do that. And I tell your Lordship the solution. What's the free rein, Malaj? He cannot deal with a disqualification unless there is a disqualification petition. He has no right to suo motu deal with it. Well, the disqualification petition will come under 21A or 21B. 21A, if he violates the whip, what's the free run for the speaker there? In this, what happened? On the 3rd of July, at the time of the election of the speaker, the whip in the house was Sunil Prabhu. He had not been changed. He directed that the Shiv Sena candidate should be voted for by these defectors. They voted against. They elected the BJP candidate, not the Shiv Sena candidate.
Interestingly, both your argument and the argument of the other side, which espouses the Nabam principle, rely on the same principle, namely the importance of the speaker. They say, because of the importance of the position of the speaker, it's important that you must exclude any possibility of conflict of interest.
No, where is the conflict?
You say that in view of the importance of the position of the speaker, allow him to decide.
No, I say don't allow an elected government to be toppled in this fashion. No, don't allow the verdict of the people to be toppled or an elected government to be toppled in this fashion. That's the fundamental principle. A government stands elected till it is removed, and it cannot be removed through the machinations under the 10th schedule. That's my contention. Let's forget about the speaker or no. This is the fundamental principle of democracy. And if you have violated the 10th schedule, allow the speaker to decide. He can't decide contrary. If there's a whip that has been issued and somebody votes against the whip, what leeway does the speaker have? You are giving a leeway to the other side, disabling him, toppling the government, and then not deciding the matter. I remember, when the Rajasthan matter came up on this court, Justice Arun Mishra, on a daily basis, used to monitor the disqualification proceeding. On a daily basis. When it came to Rajasthan. When it came to Goa, for 2.5 years, we kept on telling the Chief Justice, please have the matter heard, please have the matter heard. Where do we go? These are all nice principles of law, but you have to have a functioning, working democracy. This is why it's far too serious, Mother. The fundamental principle is keep an elected government that is already elected in place, keep it in place till such time as it can be thrown out. Of course, it should be thrown out, Malaj. And that is not to be decided in the legislature, Malaj. Kindly appreciate what is happening. This is another very interesting thing. And it's something that your Lordship should think about. 5 people in Goa, say 2 of them, or 3 of them, Malaj, are taken over by another party. The government falls. Or 4 of them are taken. The argument is that under the principle of merger, since they have merged with another party, right? Now, what is the party? The Congress party still remains. Those 3 of only legislators have merged. The party still remains. It happens in the Rajasthan also. The BSP people, Malaj, have merged, but the BSP still remains. So what we are now doing, we are allowing the manipulation within the Legislative Assembly to topple governments through means that your Lordship and I are aware of. The purpose of the 10th schedule was not to allow that to happen. Not to allow that to happen. That was the purpose of the 10th schedule. Previously, it was 1/3 in paragraph 3. They said we removed the 1/3 because it was being used to topple governments. Now there is no paragraph 3. Now a bogey of majority is raised. Because if a minority can be bought, majority can also be bought. But to what end? To topple the government. And not to allow the speaker to decide the matter. Whereas who can say, person sitting of one party in Guwahati, saying that he has not voluntarily given up membership of the party, it stares you in the face. He is passing resolutions from there that I remove you from chairmanship, I remove you from this office, I remove you from that office, I appoint myself. That's not supposed to be voluntarily giving up party. They are all arguing on the assumption that they are right when they say that there can be no disqualification for these acts. That's how they are arguing. and that the speaker, deputy speaker will malafidely say that they stand disqualified. You can't make a constitutional assumption like that. That's the assumption they are making. See what the speaker is doing. He only gave us 2 days notice. Why did he give you 2 days notice? Because the facts stared him in the face. That's the reason for the 2-day notice. Now, your lordships, when dealing with the merits of the matter, will decide whether that was enough, not enough in the facts of the case, but that's on merits. But the issues are far larger. And if this is allowed, it can happen anywhere, and it will happen. It has happened. This is not the first time. The constitution makers were aware of the difference between removal and disqualification.
Yes.
They were aware. They never incorporated, as your lordship has said also. When the amendments were taking place during this time, during the in 91, 93rd amendment, they never incorporated any of this. And the reason was that when you talked about removal, it was an entirely different regime. That is, constitution uses the word removal, not a no confidence. But as your lordship knows, in a no confidence motion, you don't have to give a reason. The house votes and you are out. But in the case of a removal, you have to give reasons. You don't say nabam rebia. In fact, this petition could never have been filed against Malaz on 27th, on 26th for an order on 27th. This is no notice in the eye of law. The member in whose name the motion stands in the list of business shall, unless makes a statement conveying unwillingness to move the motion. So Malaz, this is the point I was making. Even when the motion is in the house, he may not be willing to move it. So there can be no injunction for him to continue with the 10th schedule and the proceedings. Because the resolution, let me tell you, I have some experience in Parliament, let me tell you what happens. What happens is that whenever a resolution...
But according to you, there can't be any injunction at all, irrespective of the stage of the motion.
Yes, because that is to him. This third...
even if it is admitted, there is no bar on
No. Even during the 7 days.
Yes. I tell you, lordships, why? The 10th schedule deals with strangers. The motion deals with him. The 10th schedule deals with third parties. The motion deals with him, so he cannot preside on that particular day when it's under consideration. Well, what has got to do with third parties? Now, these issues were never discussed in Nabam. That's why Mahrankar says, that's why Malaz is allowed to participate in the proceedings of the House. He's allowed to speak, he's allowed to vote. That's why I was telling your lordships my experience in Parliament. What happens is, Malaz, supposing there's a bill, forget about this removal. There's a bill, Malaz. What do? We stand up and I say, do I have the leave of the House to introduce the bill? The House is asked for. The leave is granted, I introduce the bill. But it's only introduction. Then, Malaz, the matter goes to the Business Advisory Committee. In the Business Advisory Committee, after discussion with everybody as to when you should bring the bill up, Malaz, then a date is fixed. Then on that particular day, Malaz, some other matter may be going on, Malaz, it doesn't come up, it goes on to the next day. Then, Malaz, when it comes up on the next day, we rise in our chair and we say, that I propose to move the bill for the consideration of the House. That's when it's considered. The same procedure applies. So this whole argument at the time of the problem with Nabam is it says the moment the notice is given, you can't function. That's what Nabam decides for us. Therefore, these rules are all ultra-virus according to Nabam. Because he can't preside. So these are serious issues. And there are live issues, these are not dead issues. Especially in the context of that letter, notice on 22nd, dated 21st. The idea was not to allow the speaker to function. The whole purpose was that. Now your lordships put to me, but then it's a free, and rightly so, that the speaker has no impediments in his way to decide the matter. But that's what Hollowan says. What does 110 of Hollowan say? There can be no legitimate action before he decides. That's 5 judges of this court. Therefore, the 27th order could not have been passed. Your Lordship put it to me that no, he only adjourned it. In the interim, I adjourn it. I give them time to file a reply. What does in the interim mean? You extend the time, I can't decide. What else is it except stay? What else is it except violation of para 110 of Nabam Rebia? What else is it but it's a quitimate order? Can you put it in any other framework? No, I'm sorry. So Nabam, Holohan says you can't interfere. If you can't interfere, then the speaker has to decide. And the whole problem arose because of the 27th order. That's a live issue. That's not a dead issue. That's not academic. Because it was on 2 grounds. Nabam Rebia and 2 days notice. So if that was bad, everything will go. Because then what it catapulted into a situation where an elected government is toppled. Because of the disqualification of the deputy speaker not being able to decide. So my respectful submission to your lordships is that 179 for removal operates in an entirely different field. Now I must also disclose to your lordships that the Maharashtra rules do not have this what the Lok Sabha rules have.